All right, hello everyone. This is your pal Randall, Legislative Director and Vice Chair of the Pennsylvania Association for Rational Sexual Offense Laws. I am speaking to you from legislative headquarters here in Harrisburg, Pennsylvania, beautiful, peaceful Harrisburg. And I wanted to give an update on Torsilieri, this momentous case which appeared before the Supreme Court of Pennsylvania earlier this year. We really haven't heard any news on this in some time, and I wanted to give all of our supporters and anyone interested in these issues a little update on where we're at, where we're going, and what we might expect. So to go far back, I'm taking a look at one of the documents you can find on our website. It's the timeline of Pennsylvania's registry. So to give great context, Pennsylvania had its first sex offense registry, public sex offense registry, enacted in the year 1995. And since then, the Megan's Law, if you will, or the Sex Offense Registry, or as is now known as SORNA, the Sex Offender Registration and Notification Act, has been subject to legal challenges every few years. The first time that portions of this law were deemed unconstitutional is in 1999, and it didn't take long for it to happen again after a legislative band-aid was put on it, if you will. It was ruled unconstitutional again in 2003. This one lasted a little longer because it wasn't until 10 years later when the third time portions of this law were ruled unconstitutional. That's in 2013. And then we took a couple of years off, and there were a few more court cases, and it was ruled unconstitutional for the fourth time in 2016. So here we are, 2023, and we are gearing up for number 5. So obviously we have a law in Pennsylvania that if you are convicted of certain sexual offenses, then you must register on this website for a period of time which is determined by your crime. And we have 2 sets of laws in Pennsylvania for the registry based off of a 2016 case and a 2018 law that set up 2 systems for our registry, one for people who committed crimes before 2012 and one for people who committed crimes after 2012. So, again, as I mentioned, every couple of years we have a court case that challenges the constitutionality of this registry, and once again we had a court case that challenged the constitutionality of Pennsylvania's registry. It happened on May 23rd, 2023. May 23rd, 2023 is when Torsilieri had the final oral arguments before the Supreme Court of Pennsylvania in Harrisburg. And this winding case, started in way back several years ago, even prior to when it reached the Supreme Court in 2019. It was winding its way through the courts, and what this person said is that he was not a high risk of committing additional sexual offenses, and he did not deserve to be on this sex offense registry. So the background of his case and what he was arguing are things we've talked about in other videos and other reports and articles. So do check out our YouTube channel, do check out our website if you want to learn about what Torsilieri was arguing. But what I wanted to do today was give you a little recap of what happened at this most recent hearing at the Supreme Court of Pennsylvania and kind of what went down. So the justices of the Supreme Court are numbered 6 right now, and these 6 individuals will be weighing the merits of the 2 arguments that were brought before them. The first person who went before the judges to make their final case in this case challenging the registry was the Commonwealth. And the district attorney for the Commonwealth, his name is Mr. Eisenberg. He went before the justices and he made a few claims. So the one thing he said is that what is at question here are legislative facts, not judicial facts. And what he's saying is that this law was created by the General Assembly, by our representatives and our senators, and they used their best judgment. They did the best job they could, knowing what they knew, to create these laws. And so this person argued before the court that this isn't really an appropriate challenge to be challenging the sex offense registry in a judicial way. He says this is a legislative matter. And, he points to the evidence and the research that shows that people with sex offenses have a low rate of recidivism and that the registries are ineffective. And he says, hey, I see that, but that doesn't really matter because the General Assembly has their own beliefs and knowledge about what is true and what is needed in this state. And what he would argue is that from their own human experience, and he did say this in the court, is that they know how harmful and how serious sexual offenses are, and that these strong laws that deprive people of liberty are necessary and needed and effective at doing what they want to do, which is preventing other crimes and keeping communities safe. And so this guy said, hey, I hear you about the research, but we're not weighing research here. We're weighing what is the best for the Commonwealth. And who can decide that? Our elected officials. Those are the people who can decide that. And so, Your Honor, this is not really a good place to challenge this. The General Assembly has the power to make laws. They did the best they could in the public interest, and that's how we have to organize ourselves. So the district attorney went on and he said that the lower court, that is the Chester County Court, who already determined that the registry today is unconstitutional in Chester County, and you can read that opinion on our website. He said that the lower court considered a battle of experts. There was no mention of the heavy burden that the legislature must weigh. He talked about the death penalty as an example. There are arguments on both sides, but the legislature is tasked with creating these laws, and we have to go with the wisdom of our 253 representatives have determined. So he talked about, what does high mean when this research shows that people with sex offenses don't have a high rate of recidivism. Well, he says, what does high mean? To some people, 1 out of 5 is high. When you consider the seriousness of these crimes and the harm that is the potential for harm there, 1 out of 5 is too high. To finish out his opening remarks, so to speak, he said that the irrebuttable presumption issue, that is the issue that the claim of the legislature that all people on the registry are a high risk, that's the irrebuttable presumption at question here. This issue needs a policy answer, not a factual one. He says because there is not a consensus on recidivism, the balance or the deference or the trust, so to speak, needs to go to the legislature. So again, we don't need a battle of experts and figures and statistics. We need policy. And who makes policy? The General Assembly. And they've already made their law, and they are doing it in the interest of the people. He says that there are no perfect laws. The legislature doesn't have to rely only on posted and researched recidivism rates, the district attorney argued. He says that they incorporate things like the dark figure, that is, crimes that never get reported. They incorporate political influences and what their constituents want and need. And they incorporate the fact that reporting is difficult for victims of sexual offenses. He admits that all laws are under and over inclusive. There's no perfect law. There are going to be outliers. There are going to be things that fall through the cracks. This is the nature of our governance. That the General Assembly did the best job they could. They are acting with good faith. He says all laws are going to be under-inclusive and over-inclusive. There is no other way. This is the system that we use in Pennsylvania. So there was a give and take with the justices and the district attorney, and one of the things that one of the justices said about the irrebuttable presumption, again, which is this idea that a law cannot make a claim that cannot be demonstrated to be true, and that a person cannot challenge. And that's what happens with the registry. The registry presumes that everybody has a high risk of reoffending, and there is no way for somebody on the registry to prove otherwise. There is no challenge available. There's no means for somebody to demonstrate that they're not in fact a high risk. They're all swept under this one rug. They're all caught by this one large net. And to investigate this, the court asks, or a legal body asks whether the presumption is not universally true. So to determine whether or not an irrebuttable presumption exists, which again would be a bad thing, which would be illegal, which would be unconstitutional for it to have an irrebuttable presumption, to determine whether or not this exists, they ask the question whether the presumption is not universally true. So whether the presumption that all people with sex offenses have a high risk, is that not universally true? And in this case, it seems rather clear that it is not universally true because of the vast research that demonstrates that people with sex offenses do not have a high risk of recidivism. So it seems pretty clear that the General Assembly cannot make that claim, that all people on this list are a high risk. That's an irrebuttable presumption because there's a lot of evidence to the contrary. So in challenging the district attorney, one of the justices said, you don't win if this test, what I just described, says not universally true. You, instead, you want this test to say never true. And if you go back and listen to the arguments, they spend a fair amount of time on this. And where do you find these arguments? You can go to the Supreme Court of Pennsylvania YouTube channel and stream the arguments from May 23rd, 2023. So she tells the DA, you wanted to say never true. And I've been kind of racking my brain on this, and the way I've come to understand it is that the DA is kind of saying, hey, the claim that people with sex offenses reoffend a lot is not never true. See, we have at least one study that says it is true. And so it's not never true. So that's kind of a strange way of putting it. And for me, writing it down and kind of saying it out loud was a better way to understand it. But what he's getting at is that there is at least one study that shows or suggests that people with sex offenses do have a high risk of recidivism. And so he is saying, and he's arguing, that the General Assembly's claim that people with sex offenses have a high risk of committing another crime, that statement is not never true because of the one or two studies that show that it or suggest that it is true. So again, the justice kind of grilled him on this and asked him over and over, you want this law to say never true. Sorry, it says not universally true, which speaks to a consensus, right? Or speaks to the vast majority of data or of research that happens. And that is true, right? From if you want to go with the majority of data, the claim that people with sex offenses have a high risk of recidivating is not universally true. So the DA was kind of squirming there and trying to talk his way out of that. But that's something that seems like kind of a point of contention and something that the Commonwealth is going to have to deal with and probably won't prevail on. Unfortunately, the district attorney did bring up the everyone's favorite Smith case from the Supreme Court of the United States. He says that this case before the court right now is different because there is not a clear consensus. Even the Supreme Court of the United States cites the high risk in their case of Smith. And for those who have followed this topic, you've heard this name before, Smith. One of the remarks from the justices, which was encouraging, was that clearly, if 80 to 85% don't reoffend, then clearly the risk is not high. And then the arguments took a turn that I was not expecting, and that none of us were really expecting, but seemed to kind of dominate the conversation for some time. And again, I encourage you to listen to these arguments for yourself. Put it on 1.25 speed or 1.5 speed, and it'll go along. But he started talking about guns. He started talking about Second Amendment. So he suggested that if this court decides that PFRs, that is persons forced to register, if people in the registry, if they need to have these fundamental rights respected, their right to reputation, then we will have to allow all people, even those with felonies, to carry guns, which is another fundamental right. And again, this discussion of guns and this kind of head scratching and consideration of, well, maybe you have a point there, and where does this stop, and where do we draw the line about people with crimes and deprivation of fundamental rights? Where does it stop? It went on for some time, and it did dominate the discourse. And so, again, the attorney's argument was, if we are going to concede that you cannot deny fundamental rights from people, then we have to apply that in all cases, and we are going to have to allow everybody to have their fundamental Second Amendment rights respected. And what he was suggesting, without saying it, is that we're going to have dangerous people with felonies in possession of firearms, and that this is going to be a serious harm to public safety. So what the laws are around the Second Amendment in Pennsylvania and in the United States, I do not know. That is not my area of expertise. But I can say that, as one of our other board members pointed out, this is different. This is different for people's right to reputation in the state of Pennsylvania, which is what we're examining here, a Pennsylvania state law, because of one important point of the right to reputation in our state's constitution. And that important point is a single word, and it is the word irrebuttable. Irrebuttable. That's what it says in the Constitution. It says that in our Pennsylvania Constitution, residents of this state have an irrebuttable right to reputation. And that's not a direct quote, but if you read the Constitution, it says that we have certain irrebuttable rights, including ... the right to reputation. Irrebuttable, and that means not able to be severed. It cannot be severed. It cannot ever be severed. It is a strong word, and it's never been officially defined. And unfortunately, no one in this courtroom invoked that word. Nobody thought to bring it up or thought it was important enough to bring up. But from our analysis, it's the linchpin. It is the most important thing. The word irrebuttable precedes the right to reputation. And so if a person needs to have their Second Amendment rights to bear arms infringed, they can make a legal argument for that, and perhaps it's going to have more strength to bear because that particular right does not say irrebuttable. And again, that's not my wheelhouse, but I can say for this particular case, in our state's constitution, it is very clearly written that the right to reputation is irrebuttable. And if we're going to subject people to a lifetime of punishment to be on a public sex offense registry, that is what we're examining in this case. Is that an infringement on one's right to reputation? So that more or less concluded the district attorney and the Commonwealth's arguments. And next up, it was the defense. And Aaron Marcus, who works for the Philadelphia Defenders Association, once again appeared before the justices of our state Supreme Court and began to get grilled. So he started out his opening remarks, and among other things, he mentioned that we can and we do identify people who are high risk. And what he's getting at is that we have a law which paints with a very wide brush. It casts a very wide net and makes assumptions about everybody who has ever been convicted of a sexual offense, about their risk to society. But we have never taken the time to evaluate these people who may or may not be a high risk. And he says that we have the tools to do that. And he seems to suggest that if we just did that in this state, instead of painting with a wide brush and deciding who needs to be on this list solely by, conviction or not, then we could do a better job of respecting people's rights and protecting the community. So he says that we have tools to identify high risk. And he was cut off by one of the justices. The justices said, okay, but the legislature decided to do it this way. And she's getting at what the district attorney mentioned, that, it's the General Assembly's job to protect the public and do it in the best way that they can. And so that's what these justices do, right? They grill you, they challenge your thinking, and they want to hear what the response is. They then asked the defense, doesn't a conviction itself impact one's reputation? Where is the stopping point for claims on reputational harm? And so this is something that they're going to be grappling with. This kind of gets to the crux of the issue. Is this an infringement on one's right to reputation? The lower court certainly said it was, but we will see what our state's highest court has to say. Aaron Marcus talked about the guns example. He says that it's not a fair corollary, not a fair example. It does not apply here. He says that the Supreme Court of the United States has proven this with history and with content. I suppose he's talking about challenges to infringements on Second Amendment rights. I'm not familiar with those. And one of them, whether it was Aaron Marcus, the attorney, or one of the justices, they did mention also that there is no public gun registry, and that separates this example from the gun rights case. Aaron Marcus was forceful and mentioned that there is consensus. Contrary to what the Commonwealth and the district attorney said, there is great consensus, overwhelming consensus, that people with sex offenses are not a high risk. This is not an outlier. This is what every expert and researcher has found. To that, one of the justices, fired back. Well, the legislature said that persons forced to register are high risk. They did not say they are the highest risk. All they said was that they are high risk. Examining statistics and research doesn't speak to the idea that they are, in fact, high risk, not that they did or did not reoffend. What the legislature has identified here and made a priority is that sex offenses are serious crimes and that they are high risk. One of the other justices asked, why should this court continue to argue the irrebuttable presumption? This justice made a reference, and hopefully somebody who has a legal background listening to this can tell us more in the comment section, but they said that the Supreme Court of the United States abandoned this argument in the 1970s. She mentioned something about strict scrutiny, but again, I kind of didn't catch or understand that. The justice went on talking to the defender, and they asked him, Mr. Marcus, would you be satisfied with a SOAB, that is a Sex Offender Assessment Board? That's a body we have in Pennsylvania that decides policy and treatment goals and criteria for people with sex offenses in the state. Would you be okay, Attorney Marcus, with an SOAB-approved designation and registry placement? What if they did the evaluation and decided on the registry? What Mr. Marcus's reply to that was, I do not recall. The justices asked or mentioned that your statistics that you're citing for all of this research, these stats are based on convictions. Well, the legislature's laws are not based on convictions. As the district attorney for the Commonwealth said, they factor in other things like the dark figure, the difficulty in reporting, and public safety, and those needs. Aaron countered and replied, he remarked that this issue is different because the legislature is starting with the presumption of risk. Kind of winding up here, one of the justices asked Mr. Marcus, why not do this challenge as applied? Why don't people who are on the registry just come before a court on an individual basis, prove that they are not high risk, and get relief from the registry in that way? To do it as applied differs from how you are asking us to do this, Attorney Marcus. You are asking us to challenge or strike down this law facially. That is, that this ruling will apply to everybody in the state. If it was just as applied to Mr. Torsilieri, then that means Mr. Torsilieri would be off the list. But what is being argued here is a facial challenge to strike down this entire law. And this is a heavy lift, is what the justices were saying. To override, a co-equal branch of government, the entire statute is a big deal, is kind of what they were getting at. And so the attorney mentioned that a post-deprivation hearing is not a reasonable scenario. And what he's getting at is people would already have the harm inflicted on them by being on a registry. And by the time they got their day in court, it could be months or years or several years before they get relief. And so his counter again was a post-deprivation hearing is not a reasonable scenario. It wouldn't make sense to inflict, the public humiliation and the shame and the deprivation of rights and the registry requirements and the threat of felony conviction if you don't comply, to impose all of that and then give a person a chance to have that removed. That's not how the law works here, right? You respect an individual's rights up until they have, broken a law to necessitate punishment. And in this case, they've already received their punishment and done their time. And then what he countered, and he kind of started to explore, is that we could, in theory, do a SORNA hearing at sentencing. We could have the facts of the case and kind of an evaluation done at the time of sentencing and incorporate that into the punishment. But he didn't elaborate on that idea very much. So one of the final things the justices said is the solution to a denial of due process is to provide due process. And what he's getting at here is that, again, the claim that an irrebuttable presumption does not give a person any hearing or any format or any stage, any venue to challenge the fact that they're considered a high risk. Well, the solution to a denial of due process is to provide due process. And so that's really all the notes I have for the case and what the justices talked about. And from talking to other people in PARSOL and other people who have a better legal grasp than I do, they're talking about posturing and kind of getting ready. So they talked about the guns issue, and about how, in their opinion, the person I was speaking with who listened to the case with me, the state is kind of getting ready for losing this case. And they're kind of setting the stage for the battle in the public mind about what we're going to do with people who used to be on this registry, who now apparently cannot be on a registry anymore. And they're kind of setting the stage for framing this in a fear-based model, if you will, of if we respect the rights of these people, then we're going to have dangerous people holding guns, and your lives will be in danger. The very last remark I had from the Supreme Court as far as the solution to a denial of due process is to provide due process might be another clue as to what the solution here could be when the Supreme Court writes their opinion. Perhaps they're going to necessitate individual evaluations. Perhaps that will be for people from now on who commit a sexual offense. Perhaps that will be retroactive for all of the 20,000 some people on Pennsylvania's registry. But bottom line, and I stress this with two underlines, is that we don't know. we don't know until this case is decided upon. And the Supreme Court justices have their work cut out for them, and they're going to take their time. This case was heard in May of this year, so we're looking at 2.5 months, almost 3 months that have passed. And one of the questions we get a lot is when? When will we have a decision? When can we expect the next move and the final chapter in the Torsilieri legal saga? Because we have a whole legislative saga after this. But as far as the last chapter in the courts, when will we get a decision? And I'm sorry I don't have a better answer for you, but the answer is, I don't know. I don't know. It could take several more months. It could, in theory, come out this week. No one knows. Of course, we are keeping a close eye on the courts and the releases, and we are eagerly awaiting a decision. We will be releasing a press release and doing press outreach and doing our best to publicize and interpret the results for you. But I'm sorry, we do not have a firm date on when we can get a decision from our state Supreme Court on the constitutionality of our current sex offense registry. One thing that I can share with you is that we have a tied court right now. And what I mean is that we have 6 justices sitting on the bench. We do not have the usual 7. One of them died, I believe it was last year. And so in the case of a tie where 3 justices feel that these or portions of this law should be unconstitutional and 3 feel that it should remain, in the case of a tie, the lower court ruling stands. There cannot be a tie in cases at this level. And so all that is needed for significant judicial reform for Pennsylvania Sex Offense Registry is for 3 justices to take the stance that all of this law or portions of this law is or are unconstitutional. So what's next? What's next is educating the people who will be charged with cleaning up this mess when the court makes their decision. What exactly will that look like? This court's decision, we don't know. It could very closely mirror the decision from the lower court, which very strongly words that this registry is unacceptable and unconstitutional, facially, fully, for several reasons. It could be halfway there, or we could receive news that, sorry, this law is constitutional, and despite the issues presented, that the law stands. So again, it's anybody's guess, and that makes our outreach a little more difficult. But what we are doing as far as next steps is reaching out to state legislators who are going to be tasked with the responsibility of adjusting the law if the Supreme Court decision mandates that an adjustment needs to be made. And so we've been in touch with the chairs of the judiciary committees in the House and the Senate. We've brought this decision to their attention. We've asked to stay in touch. We're going to be doing more outreach to the rank and file members of the Senate and the House, particularly the ones on the Judiciary Committee, because that's where changes to this law will have to first be heard before they're voted on in the full House or the full Senate, and well before they will be signed or vetoed by the governor. Again, the Judiciary Committee, which is in the House, there's also one in the Senate. It's made up of, in the House, about 18 to 20 individuals, and in the Senate, about 9 to 10. So these people are a little more important to convince so that we can get a good start on getting positive reforms made. Research-informed improvements made. Prevention-informed improvements made when the effort is made to comply with the Supreme Court's order. So we have a great opportunity here to incorporate the research on prevention, on public safety, into our laws, and to truly reach that goal, which I am sure that our General Assembly does in fact have. I truly believe that of course, the men and women in the House of Representatives and the Senate want to keep the public safe and prevent sexual crimes from happening. We have a great opportunity to do that more effectively through a public health approach and education on consent and grooming and risk, and how these crimes happen and where the risk is. And we have an opportunity also to better respect the individual liberties of people who are affected by the sex offense registry. So please join us. We need more people to contact their state legislators. The more people that they hear this from, the more it will become apparent that this is an issue that people care about and that is affecting people. And we can't stay quiet on this. We can't be shy or bashful about what we know and what the experts in the field tell us and what we've experienced in our own lives and in the lives of those we love. And so check out our website again for more information on how you can get involved with meeting with your legislator later this month in August 2023. We're going to have a lobby training where we'll answer all your questions about how to get through to your senator or your state representative, about how you set up a meeting, what you say, how you say it, when you say it, who you talk to, who you email, and we hold your hand every step of the way. We have people who have done this before, and there's plenty of ways to get involved. If you want to do it over Zoom, great. If you want to write a letter, fabulous. You want to make a phone call, that works. You want to come with me to the Capitol in Harrisburg and sit across from these people and look them in the eye and tell them exactly how you feel and what we know, even better. So that's all I really got for you for Torsilieri. Pardon me for the delay. It's been, again, 2.5 months since this case was heard. I'm glad to share some of the notes that I had with you. Thank you for your support for PARSOL. Please tell other people that are affected by this issue about the work that we're working on. If you haven't subscribed to this channel yet on YouTube, please subscribe to us. Please like this video, share it with a friend who might have a legal mind or who is affected by these issues. And yeah, you can find us, of course, on our website and on social media. Just look for PARSOL and the Pennsylvania Association for Rational Sexual Offense Laws. I am Randall, your legislative director, and we will continue to follow Torsilieri closely, as well as any other legislation or court cases that come up that affect people on the sex offense registry or sex offense policy in the state of Pennsylvania. Enjoy the rest of your summer. Be well, and we will talk again.